From WKNOW, this is Steve Chanley with One Question Too Many. Today's program is made possible by the law firm of Employer Advocates Group, serving California employers since 2002, with offices in Orange County and San Luis Obispo County, California. eaglawgroup.com. We're joined today by Judge Brian Rickman. He's the Chief Judge of the Georgia State Court of Appeals, where he has presided since 2016. Prior to being appointed to the bench, Judge Rickman was in private practice and was also a state prosecutor. Thank you for being with us today, Your Honor.
What a privilege. What a privilege. One quick correction. I'm no longer serving as chief. I served a 2-year term and then stepped down into a role presiding judge, which is our tradition. So I'm technically just a presiding judge now. My term as chief ended in 2023.
How long have you been an attorney?
Been an attorney since 2001. I graduated from the University of Georgia Law School, took and passed the bar in 2001. So I cannot believe I'm saying this, but of course, coming up on 20, right at 24 years. Took the bar in July of 01. So yeah, coming up on 24 years.
You're a native of the Peach State, correct?
Yes, sir. I'm born in rural Northeast Georgia. Currently live in Rabun County, Georgia. If nobody knows where Rabun County is, the Chattooga River is here. Tallulah Gorge is here. If you're football fans, you might see lots of references to Coach Nick Saban's lake house, which is here on Lake Burton. And also, fun fact, the movie Deliverance was filmed here in Rabun County, if you've ever seen that movie.
I have. Okay, I have to ask you this. I read that you worked as a jailer before going to school at Piedmont College. How old were you?
Yeah, I was right out of high school, between 17 and 18. It's a great story. My former sheriff, Don Page at the time, is a cousin of mine. When I graduated high school, my initial plan was to go to college, and I wanted to go into state law enforcement. And his advice was, come hang out, be a part-time jailer over the summer. You need to see what law enforcement actually looks like before you go commit 4 years of your life in education. And so I did that straight out of high school. And in those days, 1994, that was when the old Rabun County Jail was there. It was literally, in some ways, a lot like Mayberry, although you had serious crimes, lots of different, pretty historic murder cases. But that was my time as a jailer. And it ultimately put me on the path of becoming a lawyer, because one of the things I did that summer was work in a courtroom, assisting in a courtroom. And if anyone is following national news with the trial of Sean Puffy Combs in New York, one of the first lawyers I ever saw in a courtroom was a young man named Brian Steele. He's a criminal defense lawyer in Atlanta. He was in Rabun County defending an early murder case. And I got to watch that case, and it helped stoke a passion for the courtroom.
What were your duties as a teenage jailer?
Yeah, so in those days, there were probably, you had a jail back then. It's well over 100 now. Back then, you probably had 30 to 40 people in jail at any given time, and it was hand out chow, hand out medications, you name it, book people in. I actually have a cousin of mine who also was a jailer who just retired from the U.S. Secret Service. And we always joke with each other, if we'd stuck to what we were doing, we could have been jail supervisors by now.
That would have been quite a different career path.
Yeah, that's a little mountain humor.
Was there something about the work that you did as a jailer that, as you said, stoked your interest in studying law?
It was just fascinating, Stephen. As a young person, when you're talking to grown adults, all of whom have some sort of interaction with the legal system, and you go into it with a reference from television or from stories, but you're sort of eyeball to eyeball with all these different human beings, and some are charged with serious crimes, some not. It's just It's human drama. And like I said, getting to go to court and see what courtrooms look like, it was a very colorful place. You know, you had a lot of colorful characters in courtrooms, a lot of old trial lawyers that are gone now, and then just the normal fascination of this is how people solve their disputes. It just had such a huge impact on me.
So immediately upon graduating from law school at the University of Georgia, go Bulldogs,
Go
you became
dogs.
an assistant. That's right. You became an assistant district attorney. Did you plan to go into criminal law when you began law school?
I did. You know, when I went, I wanted to become a prosecutor by that time. I had decided that I really wanted to be a prosecutor. And so I immediately went and became an assistant DA pretty quickly before going into private practice. I'm very thankful that in addition to being an assistant DA, that before I came the district attorney, that I did some time in criminal defense because that gave me some perspective on what defense counsel is going through when they're trying to represent a client, what it's like to be on the other side of that equation when, you know, you're literally holding people's lives in your hand, so to speak. So I did assistant DA work, and then I was in private practice, and then became the DA. And in private practice, very much a small town law practice where people just walk in with problems, and you have to figure out how to solve them. That could be criminal defense, it could be divorce, sometimes it might be tort law, but you're more like a filter, right? And so if I recall correctly, you practice mostly in employment law. Is that right?
Yes, sir.
Yeah, so in a small town, you might talk to somebody with an employment problem. You might not be the best person to solve that, but you might you might get them to the right person through referral, and you might still be on. So people show up, want an appointment, and they want to tell you what your problem is. And that could be everything from a DUI up to a divorce, up to, I can't get my unemployment benefits. Pretty varied.
How many years were you in private practice?
I was there about 4.5 years with my former partner, Alan Stockton. He still a lawyer here in town. And then I became the DA in 2008 at the ripe old age of 30 years old.
Wow. Did the varied nature of your practice assist you when you became a DA later?
Oh, for sure. Similar to what I was just talking about with a general practice, when you're the DA and you're an elected official, people expect to meet with you in small towns and in rural places, and they expect to be able to talk to you. You can't just say, no, I won't meet with you because what you're describing is not a criminal issue. You have to sit down and listen. And then you have to say, that's not really a criminal issue. You should seek out an employment lawyer, or you should seek out a divorce lawyer. But the main thing is you're accountable to the people. Being in private practice helped me know how to get people to the right places, even if it wasn't in my arena.
Right. So you're kind of like a flight traffic controller. You need to know
Sure.
where to point people.
Yeah, people still expect to come to the courthouse and get to see who they want to see. You don't just say, must have an appointment. If you're an elected official, you're expected to meet with people. You're expected to be seen, you're expected to be accessible, and you don't just say that's not my job or that's not what I do. You have to be a good listener and, as you said, like a flight traffic controller.
So you're the district attorney for the Mountain Judicial Circuit in Georgia. How large of a geographic area is that?
3 counties. Actually, we just added another county, Banks County. So now it's four. At the time I was DA, Rabun, Habersham, and Stevens. Geographically, you're talking from my house in Rabun County, I could be to the county seats in the other two in about 30 minutes, about 25 miles to the county seats in the other counties to the middle. But they covered a pretty large geographical. If you were looking at a map, it would be the right-hand corner of Georgia and Rabun, then Habersham, and then Stevens. We border in parts of our circuit both South Carolina and North Carolina.
Do you have a team of assistant district attorneys who worked under you?
I did. About before I left, I think there were 5 assistant DAs. So smaller office in the grand scale of what most of your listeners will be accustomed to. We had 3 offices. I think I had 5 assistant DAs and myself. And of course, in a more rural setting like we are, I tried tried a lot of cases.
You were appointed in 2016 directly to the Georgia State Court of Appeal. Is there anything about being a trial judge that you kind of feel like you missed out on?
Yeah, I would say so, certainly. Trial judges are, when you're looking at a cold record, the way we do in the appellate courts, it's hard to understand the context in which decisions are made during a trial, how rapidly they have to be made, the lack of resources that a lot of our trial judges have in terms of staff attorneys and time to do research. Their dockets are so busy. So I think it's really definitely fair to say I didn't have the same perspective on environment they have to make those decisions in. I've gone back and served as a trial court judge as a substitute several times for that reason. I made it a point once I got appointed to go sit as a trial court judge to get that view. And I still do that periodically. I've done it some recently as well.
Is that fun for you?
Well, I will say fun is not exactly the word. It is enjoyable to learn, but I'll tell you, the running joke is with the appellate courts, we might spend half a day on one issue talking about it as a staff, and it's different when you haven't been in the trial courtroom in a while. I tried cases. I wasn't a trial judge, but sometimes we have a luxury. We're the replay booth, right? We get to slow everything down, look at every angle. And being the on-field referee presents some pretty unique challenges. If you have any trial judge listeners, I expect that they will be gratified that I'm saying that.
Was there anything in particular that you did to prepare yourself for the job of being on the Court of Appeal, going straight from a DA to a Court of Appeal?
Going straight to the Court of Appeals, I had tried a lot of cases. I will say as soon as I was appointed, I dove in head first to lots of material about statutory interpretation, different theories of jurisprudence, things that I had always wanted to do when I was a busy trial lawyer but didn't have time to do. I found myself focusing on theories of statutory interpretation, theories of constitutional interpretation, which we don't really do at the Court of Appeals, but does play a factor in our jobs. I transitioned from trial lawyer nerd to I became an appellate nerd.
Your response leads right into my next question, which is, in Georgia, the state Supreme Court has exclusive appellate jurisdiction over certain types of cases. Would you mind explaining that to our listeners, how that works?
Yeah, sure. So our Georgia Supreme Court has exclusive jurisdiction over constitutional questions of Georgia constitutional law, and also some exclusive criminal jurisdiction. Right now, murder, any appeal involving the offense of murder, if a person's convicted of murder, would go to the Georgia Supreme Court. When I was appointed, the Court of Appeals was expanded from 12 judges to 15, and at the same time, there was a statute passed which shifted a lot of jurisdiction from the Supreme Court to our court. Supreme Court used to have exclusive jurisdiction in equity cases. We now have that. Used to have exclusive jurisdiction in most domestic relations cases. We now have that. And so it shifted. They are primarily a cert court. They do all murder jurisdiction, constitutional question, a couple other small things involving elections where in some circumstances they're exclusive, but that's sort of the lay of the land.
If you met someone who knew absolutely nothing about our legal system, how would you explain to them the importance of the intermediate appellate court system?
Great question. I would say for the vast majority of Georgians, our court is a court of last resort. And by that, I mean, not unlike the federal courts in many ways, most cases are going to end in our court unless you get cert granted, unless it's a case where exclusive jurisdiction is with our colleagues on the Supreme Court. You're going to have in some form or fashion, in many, not all cases, but a right of direct appeal that comes to the Court of Appeals. And so our court functions almost as a court of last resort for folks who think there's been error at the trial court level. And with 10 million Georgians, with an expanding state, there's a lot of litigation and there are a lot of questions for us to answer. And it as I said, can be for a citizen, for lawyers, it can be the last stop. And for the most part, it usually is the last stop because cert is, cert is not a given, to put it mildly.
Read that the Georgia Court of Appeal described as the busiest state appellate system in the country. How large of a personal staff do you have just for yourself?
Yeah, I've got 4 employees. I've got 3 full-time staff attorneys and 1 administrative assistant, and they are incredibly busy, incredibly good writers, and we spend a lot of time together. Authoring opinions, I forgot to pull the latest stats, but each chambers is going to author in excess of 100 opinions, and you're going to vote on another at least 2 to 300 opinions and orders in a given year. And when it's an order, jurisdictional order, things of that nature, it's one thing. But as you know, as a practicing attorney, those opinions, we need to spend a lot of time on them because there are downstream consequences for everybody. Yeah, long-winded way of saying it's myself and 4 employees.
So the question to me that seems very obvious is, with that great volume of appeals, what does the court do to develop a workflow that strikes a balance between being fast and efficient while still giving enough care to each case to ensure that the parties' rights are given full consideration?
Great question. I would say our case assignment system helps because it is completely random. Other than if a judge disqualifies or recuses, we don't have specialty divisions. And so, be it a criminal case, be it a civil case, be it a tax case, be it a domestic relations case, every judge is going to handle all types of appeals that come to him or her. I think that helps because if one panel or one judge is primarily handling, for instance, class action certification, that can be extremely complicated. In addition to spreading that workload around, it also ensures the public that you're going to get a diversity of viewpoints. Your case is randomly going to go to different judges with different viewpoints. You don't have to think, oh no, they always assign the criminal cases to Rickman and he was a former prosecutor. I have no hope. So that's one way, both for public confidence and workload. And then in chambers, we do the same thing, which is most judges, I don't speak for every chambers, try to spread, when you look at your caseload in a given term, if there's a huge case with 15 volumes, if you give that to an attorney or it's an assigned to attorney, then you want to take some other workload off of him or her so they can work on that. Or if it's a case of first impression, for instance, if there's an employment case that you guys who practice in that arena, we know is going to be heavily relied on, we really want someone to focus in on that so that whatever we write is valuable and answers the question and provides some clarity.
Were all the judges there required to follow some uniform workflow?
In general terms, yes, the case assignments are completely random. Now, once they're in chambers, judges would be free to assign the cases that are in their chambers amongst everyone pretty much as they see fit, but all judges are going to do that equally. But the numbers of cases assigned by judge are very intricately balanced out so that you're not often going to find any one judge in our court that's carrying many more cases than another judge, with the exception that if one chambers gets a 10 plaintiff, very complicated litigation case, it might be that they get credit for having 2 cases based on the number of litigants and the number of briefs, if that makes sense.
Has your Court of Appeals adopted any form of artificial intelligence for administrative purposes?
We, to my knowledge, we don't use AI. We've been in the news a little bit because we've had some briefs. We've had some opinions that involved early AI being used on briefs. And we had a situation where, I don't remember if it was New York or New Jersey, but there was a brief filed using AI that I think the term that most folks are using is hallucinated. It hallucinated some Georgia cases that didn't exist. And there was some press coverage about that, but we are investigating all aspects of AI. We're not using anything AI just yet, with the exception that, I know that there are some search tools from AI that everybody, I think, would have access to use, and there's no prohibition on using AI for searches, but I don't think we're doing it for workflow.
I can tell you it can be very effective for summarizing documents and can save a lot of time in
I'll tell
that
you,
way.
funny you mentioned that. 2 nights ago, I used ChatGPT for the first time just experimentally. I finally decided to drag myself into the 21st century, so I tinkered around with it. I'm the last person in my house and probably the next to last person on my court to do so, but it's fascinating.
It is. Do you have a favorite area of the law when it comes to deciding appellate matters?
Probably criminal law because it's my safe harbor because I did that. I enjoy Fourth Amendment cases. I find them to be fascinating. Tort cases, I enjoy working on because tort cases are similar to criminal law. You have elements of a tort, like you have elements of a crime, and you have discovery, which points one way or the other, so to speak, sometimes. But probably criminal. I really enjoy Fourth Amendment writing. And enjoy Georgia criminal procedure cases because I spent so much of my time doing that.
How gratifying is it when the Georgia Supreme Court affirms one of your appellate decisions and adopts your personal analysis of an issue?
It's pretty gratifying. Whenever I've got a lot of good friends and colleagues up there, a lot of bright folks, and I think it would be disingenuous to say that when they echo what you said, or could even be a dissent, when they take a look at a dissent or a concurrence you wrote and echo that back, that you put a lot of work into. There's definitely some gratification in knowing, okay, for lack of a better term, I'm not crazy. Somebody else sees what I see. So I think it would be disingenuous to say that there's not a little boost from that.
Have you had any cases go up that involved issues of first impression?
Yes. Right off the top of my head, I recall having an apportionment issue that was a case of first impression. I recall having, I think, a guardianship case. I'm brainstorming them through right now, and some reversals, some affirmances. So I've had one or two go get sent back, and I've had some that were affirmed. I've been on both sides of that coin.
That's a very interesting aspect of how the law is developed with issues of first impression that they require a lot of analysis and balancing of public policies and then also giving due respect to prior decisions that are similar and possibly straightening out some former decisions that weren't correctly decided. So it seems to me that would be a very rewarding and intellectually challenging aspect of your job.
Definitely, and well said. I think I got a colleague, Steve Dillard, who always likes to joke that there's a reason there are no television shows about appellate law, because if people actually saw day in and day out, it's not going to be something that is going to be relatively exciting on TV. Very exciting for me, and I wish folks could see what goes into those decisions. Sometimes when we come up with an opinion, 20 pages, but it really doesn't reflect how you agonize to get to the right answer. And unfortunately, people just don't get to see that process. But again, if you made a documentary about that process, there's only a handful of people, that maybe some of your listeners, but not too many, that would tune in.
Were there any tips about briefing that you would give to attorneys who are appearing in your court?
Yeah, great question. The thing about briefs, when I got to the appellate court and I realized the environment that we're consuming that writing in, and when I realized the people that are actually reading it and what makes a difference in their mind, I realized most of the writing I did was just not great writing before I got there. The biggest tip I have is, number one, when you are very passionate about a case, well, in every case where you do an appeal, if you were the trial counsel, you need to let someone review your brief that knows nothing about your case and that does not have a personal attachment to your case, because the judges and staff attorneys that are reading that case don't know anything about your case and don't have a personal attachment to it. And if you let a friend or colleague who doesn't know anything about your case read that brief and they have questions, there's a better than 50% chance that those questions are going to pop into our minds when we're reading it too. So if there's two lawyers that go and fight a case out together as co-counsel, and they're the only two that are looking at the brief, that's a difficult proposition because there are things in your mind that are self-evident because you've lived that case that you may forget to point out. They're just self-evident to you. So that's a tip. And tip 2 is I've yet to read a brief or an opinion for that matter. And I've put some opinions out like this that couldn't be simplified or shortened. I aspire to simplify and cut some more. I don't always achieve that in our chambers with my staff, but I've yet to see a brief that couldn't be simplified further, even on the most complicated topic.
I think the concern with a lot of attorneys, and this is just my perspective, is that while distilling down a brief helps create greater focus, there's at least some theoretical risk that you may not make a point that could make a difference.
Yeah, no, I think it's a great point. Well, and also you're afraid that it's something that the judge is not going to pay attention to. And I will say this as well. I understand we're not the only audience because their lives, liberty, property, businesses are all on the line. And so I do understand, and I've gotten an appreciation that we're not the only audience. There are other audiences that are involved. Strictly speaking, are we the most important audience? Well, for purposes of a ruling, we are, but I do understand too that clients are an audience too.
So you're an adjunct professor at your alma mater at Piedmont College. Tell us what that experience is like.
It's been great. I haven't taught in a few years, but great experience. I love working with undergrads. It's a good way to get me, the appellate judicial world is pretty insulated, and it's a good way to get me out and hear reactions to things from non-lawyers, folks that are interested in the law, but that are non-lawyers. Some of the questions they ask about an opinion, I think I was just talking about audiences. One of the things I try to remember when I write is that we don't just have a duty to write for lawyers, but we also have a duty to write for the public in many ways. Not that the entire public reads appellate opinions, but when it's an important issue, I think that experience has helped me remember that.
What courses do you teach?
I've done American government, courts and society, criminal law and procedure. These are all undergrad level courses, and political ideology, taught that as well.
You've served in several professional and public safety organizations before taking the bench as an appellate judge. Can you tell us about that?
Yeah, served on the Georgia Board of Public Safety when I was a prosecutor, which was the oversight board for our state patrol and the Georgia Bureau of Investigation. I served on the Prosecuting Attorneys Council, which is sort of the policymaking body for Georgia prosecutors, sort of an umbrella organization. A couple local committees, law library committee, things of that nature. I currently serve on our Judicial Qualifications Commission, which is charged with investigating judicial misconduct. We have an investigative panel and a hearing panel, and so that takes up a lot of time as well.
How important is it for lawyers to be involved in civic and social benefit organizations?
I believe it's huge. I believe it's so difficult for lawyers to do anymore, but lawyers are leaders and lawyers need to be out in our community. Easier said than done when you're trying to manage a busy private practice, but it's just so important to get out and get involved. And quite frankly, got a colleague on the Supreme Court now, John Ellington, who always tells folks there's a life outside the courthouse and you need to get one. It's difficult as it is. That time away from practice in the community will reap rewards.
I probably shouldn't ask you this since you're on the Court of Appeal, but have you ever asked that one question too many?
Yeah. Yeah. Well, and the case that first comes to mind when I thought about that, it actually kind of worked out to my benefit. So it seems like I'm not being self-deprecating enough, but the story is one of my favorites. Had a robbery case in Stevens County, It was what we call a blind plea, where the defendant didn't want to agree to the sentence we were requesting. And during his testimony before my colleague and friend Judge Smith, this was a robbery of an elderly gentleman, and the allegation was these folks went to a house to steal something, and the gentleman got in the way and they pushed him down. And so the young, I don't say young, he was in his 40s, but the defendant was arguing, why they shouldn't receive the type of incarceration that we were asking for, et cetera. And as he's speaking, he says, that isn't even really the reason why we were there. We weren't there to bother him. That's not the reason why we were there. So when it came time for cross-examination, I said, well, why were you there? And he said, well, we were there to get a gun so we could go do a home invasion. This robbery wasn't even going to be a big deal. And so he answered one question too many, but it didn't work out for him because he made the crime much worse. That was one of my favorite stories about one question too many that I remember.
That one worked out well.
I will say one other time, to be self-deprecating and not sound totally self-serving. When I was in defense practice, I had prepared a cross of a defendant, and one section of the cross was, during his interrogation, the defendant was reminded that he now had a child that had been born into the world, and he had to say he had to cooperate. And so during the cross, I reached that point and said, when you were interviewed, you cried and said you had to do this for your baby, and you'd do anything for your baby, wouldn't you? And he looked at me and said, I found out since then, though, that that's not my baby. So it's not really a big deal to me anymore. I said, wow, there went 5 pages across.
Pretty good. Can you tell our listeners how to get a hold of you if they wanted to make contact?
Absolutely. My email address is lowercase Rickman, Rickman, B as in boy, at gaappeals.us. And you can reach out to me by email. I'm also listed in the bar director, I believe, but same email address. Feel free to email me or reach out. I think that I appreciate you asking me to come on, because I think one of the things we as judges need to do is get out in public more and be on podcasts more. The opinions of the judiciary is suffering because of things people read on social media, and I think we've got to get out and let people know who we are and what we do and why.
Well, I really appreciate your being on today, and I've really learned a lot, and it was a lot of fun. Thank you again, Your Honor.
Yeah, thanks so much.